Top 10 recommendations in planning for retirement benefits under the Secure Act and proposed regulations. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Doug Stanley, ACTEC Fellow from St. Louis, Missouri. ACTEC Fellow Kathy Sherby, also from St. Louis, will share her experience and recommendations.
Hi. Planning for retirement benefits is extremely complicated, but here are my top 10 recommendations to remember when you're planning for distribution of retirement benefits after a client's passing away. Number one, you don't any longer have to worry, you don't have life expectancy for designated beneficiaries. Even though that is the case, much remains the same. You still have to comply. Number two, you still have to comply with the see-through rules in order even to get a 10-year distribution, especially if you're planning on doing a rollover from a qualified plan to an inherited IRA. So the see-through rules are that the trust has to be valid, has to be irrevocable. All the accountable beneficiaries have to be individuals, and you have to provide certain documentation to the plan administrator by October 31st. The accountable beneficiaries being individual is the hardest issue to deal with and dealing with and planning for a see-through trust. But we have a lot more rules now given to us under the proposed regulations about disregarding beneficiaries. So let's start in on how you plan for a married couple. If the client is married, then the spouse is still the best beneficiary outright because they can roll it over and use the uniform table, which is about twice the length of the single life table. But if it's a second marriage, that creates some problems. So you should consider conduit trust if the client is primarily concerned about the affairs or well-being of the spouse, or an accumulation trust if the client is more concerned about making sure that as much as possible remains for the family. You need to remember to qualify both for either one of these for the marital deduction. Number 5 is you no longer need to consider who the oldest beneficiary is. If there is no eligible designated beneficiary, you'll use the 10-year rule. But if the owner is past the required beginning date, that's going to have the age of the designated beneficiary will have some impact on the distribution period because the distribution period is the longer of the designated beneficiary's life expectancy or the decedent's life expectancy, but it's all limited to the 10 years, so it doesn't make all that much difference. Number 6, powers of appointment are now ignored unless they're exercised, and trust modifications are now a useful tool because the proposed regulations now state that the service will pay attention to a modification that happens before September 30 of the year following the year of death. So you can use a modification to qualify a see-through trust as a see-through trust or change countable beneficiaries to make sure you have all individuals. Number 7, you use an accumulation trust for a minor child. You don't have to worry about making it go outright to the minor child because the proposed regulations have a special minor child rule that allows you to disregard all of the other beneficiaries if the minor child is the sole current income beneficiary, and you get to use the minor child's life expectancy. And number 8, if you have a young beneficiary who is not a minor child, a niece, a nephew, that kind of beneficiary, you could use the age 31 trust, which requires a distribution to that young beneficiary by age 31, and you can disregard all of the other beneficiaries. You don't get to use life expectancy, but that is not what you're going after if you're using the age 31 trust. You're trying to disregard perhaps a charity as a beneficiary. Number 9, if you have a beneficiary who possibly would be disabled or chronically ill at the client's death, you would always want to use an applicable multiple beneficiary trust. Tier 1 applicable multi-beneficiary trust, which is referred to by many as an AMBIT, would be a revocable trust that immediately divides on the death of the client into separate trusts, one of which is a separate trust solely for the benefit of the disabled or chronically ill. The benefit of using this is that all of the trusts then qualify for the separate account rule, which is a real big benefit. The Tier 2 AMBIT is the trust that would be solely for the benefit of the disabled or chronically ill beneficiary for their lifetime. And number 10, if the beneficiaries of the trust are not EDBs, or the plain old designated beneficiary, then you should use an accumulation trust, an accumulation see-through trust, and not a conduit see-through trust. The only time you would use a conduit see-through trust, since you're not going to get to use their life expectancy anyway, the only time you would use a conduit see-through trust is if you were trying to disregard a charity that was the remainder beneficiary. Those are my top 10 most important things to remember in planning for retirement benefits.
Thank you, Kathy, for sharing with us your knowledge on this very complicated topic.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review. Follow us on Facebook and Twitter at ACTEC Talk.